The appointment of a receiver is almost an absolute component of any mortgage foreclosure action, and there is a great deal to the subject of receivers. But there are a few gnawing points which seem to come up with regularity, which are worthy of comment. One, a receiver is appointed and he very quickly receives a series of bills which either had been rendered to the owner, and of course the receiver has taken over in the place of the owner borrower, or bills that are sent directly to the receiver, even though the services or the goods were delivered when the owner had been in control of the property. And the receiver's question is, are these bills my responsibility? And the answer to that is no. Costs incurred by a property owner prior to the appointment of a receiver are expenses personal to the owner of the property. The receiver need not be responsible for paying those past bills. Related to that subject, and a frequent question as well, is the receiver who encounters a contractual relationship with some supplier or someone presenting services to the property. For example, one of many, a landscaper. Suppose there's a contract between the owner and a landscaper. The landscaper does certain work on a monthly and is billed on a monthly basis. Is that contract now the responsibility of the receiver? The answer there as well is no. He need not adopt that contract. Now, if a receiver believes that this vendor is a good one, and the receiver would like to continue this vendor because it is advantageous to the property, then the receiver is certainly free to do that, although not responsible for prior expenses. The approach the receiver would take to the vendor or supplier is, I like your work, I would like to continue with you, and I'm perfectly willing to pay you on a going forward basis, although I must tell you that any sums previously owed are the responsibility of the owner. If you would like to continue, then this can be a good business relationship, and that is something that a receiver can consider. Another aspect of the receivership which raises a question, although primarily in the minds of foreclosing plaintiffs as opposed to receiver themselves, is, can the receiver sell the mortgage property? The reason this question is asked by foreclosing lenders is that mortgage foreclosure actions in New York have become so protracted, difficult, and expensive that lenders would like to know that they can come to an end in a faster fashion. And the thought occurs that, well, the receiver has been appointed by the court, he is in control of the property, why can he not sell the property? Which, by the way, receivers in corporate dissolutions typically are authorized to do. The answer in a foreclosure, however, is no. The receiver does not have the ability to sell the property. He doesn't own it. He is a custodian. Case law says this. The point is firm, and although lenders would like to hear that the receiver can sell the property, there is no authority for it.